purpose of this recording is to outline in a basic way some of the concepts we'll be dealing with in our first lecture on the public international law of the use of force. There are three concepts I want to draw attention to: the principle of non-intervention, the prohibition on the use of force by states in international relations against the political independence or territorial integrity of other states, and the exception to that provided by the principle of self-defense under Article 51 of the UN Charter. I'll also make some comments about authorization to use force under Chapter 7 Security Council resolutions. So the first point to note is the general principle in international law of non-intervention. So that boils down, as I've said, to a principle that states should not intervene in the internal affairs of other states. That's a broader principle than just force. However, in the UN Charter it finds a more specific expression in Article 2.4 and Article 51. So Article 2.4, as I've mentioned, embodies a general prohibition on the threat or use of force in international relations. Now, there are 2 points to note in that language. The first is it refers to the threat or use of force, and the second is potentially qualifying words that force cannot be used against the territorial integrity or political independence of any state. Now, those words might suggest that a limited forceful intervention in another state, which did not seek to overthrow the government and did not seek to conquer territory, might be permissible. So, for example, an operation to rescue nationals being held hostage, or a temporary incursion across a border for security measures or counter-terrorism might be thought not to violate Article 2.4 of the UN Charter. In fact, what we see in state practice is condemnation of such acts, as the Organisation of American States did recently in relation to cross-border counter-terrorism operations, and also we see in the ICJ case, the Armed Activities case, an assertion by the ICJ, or rather a ruling, that temporary security incursions are not justifiable. So, moving from Article 2.4, the general prohibition, we need to look at exceptions when force is permissible. And there are two principal ones: the right of self-defense under Article 51 of the UN Charter and Chapter 7 Security Council authorization. Now, Article 51 of the UN Charter recognises the inherent right of self-defense if an armed attack occurs. Now, Article 51 refers to an armed attack, while Article 2.4 refers to the threat or use of force. So there's an interesting point there. There's a difference in language. What does it mean? Well, armed attack is a higher threshold. It's got to be something of sufficient scale and effects, of sufficient gravity, that it's comparable to an invasion or operation by conventional military forces. And we have the Nicaragua case as authority for that. So the prohibition on the threat or use of force under Article 2.4 is broader than the concept of armed attack. So not everything that violates Article 2.4 will give you a right of self-defense under Article 51. There's a gap. So the UN Charter system expects states to act with restraint when faced with an illegal use of force. So what are your options then if you can't always resort to self-defense? Well, your options are potentially non-forceful countermeasures, something we'll explore in class and in future sessions, and an appeal to the Security Council that it do something or authorise that something be done. There are two other questions that are important for us about self-defense, or the right to self-defense. And they arise out of actions by non-state actors. So the first is, can you exercise a right of self-defense against terrorism? And as we'll see in class, the judgment of the International Court of Justice in the Palestinian Wall Advisory opinion on that point is ambiguous. But there is certainly authority for the proposition that you can have a right of self-defence in response to a terrorist attack, say like the events of 11 September 2001 in New York. What's more controversial is when you can exercise those rights on another state's territory. There's also the question of proxy forces. So when you see a guerrilla or potentially terrorist movement that is in fact state-backed, at what point does support for rebel groups in another state's territory become the equivalent of making an armed attack through them? And we'll see in the Nicaragua case that the ICJ decided that supplying such groups and even providing them with extensive assistance might be simply the equivalent of a threat of force, and it's only a very high level of control that might justify the conclusion that support for such a force actually constitutes an armed attack. And as we've noted, the other essential exception to the prohibition on the use of force is where the Security Council authorises it under Chapter 7.